Hi, everybody. Welcome. Hope you're all doing well. Happy New Year. It's been a great holiday for me. Hope it's been a wonderful one for you as well. Man, do we have a lot to chat about. I thought we would just do a little bit of a recap of a few of the cases that we followed in 2023, and then maybe chat a little bit about a couple of cases maybe we haven't talked about before. So I I wondered, just out of curiosity, if any of you do New Year's resolutions or set intentions for 2024. So if you've got things you want to share in our chat, please drop those so that we can talk about what it is we're looking forward to for 2024. So you all know what I'm looking forward to in 2024. I am about maybe 3 or 4 days away from pushing send on the most of my chapters off to the publisher for a first look. I'm super excited about it, and then comes the real work of doing all the marketing and making all the connections and getting ready for CRIMECON and launching pre-sales at CRIMECON in Nashville. So I hope you all are hoping and maybe planning to join us in Nashville. I'm really excited. I've never been to Nashville, so I'm looking forward to that part. My daughter is planning to come and help with the launch, so I'm super excited about that. And I know that we're going to have a lot of friends and a lot of supporters out there giving us a hand. I do want to point something out to you. If you would like a pass to go to CRIMECON, one of the great ways that you can get one is to volunteer. CRIMECON uses huge numbers of volunteers, and they all work a few shifts, directing traffic, helping people find their rooms where they're seeing panel discussions, and a number of many other things that they use volunteers for. So if the admission ticket for all 3 days seems a little bit steep for your budget, think about volunteering, and it may be a way to get a pass and be able to enjoy CRIMECON without such expense, because I know it's an expensive ticket. So I wanted to let you know that Michelle is off tonight. She's still a little bit under the weather and in the midst of moving apartments too. So fortunately, she was able to acquire a little bit bigger apartment because she is having some family members who are going to be staying with her throughout the next few months as she's going through her chemo. So, but it meant that they had to move apartments in the same complex. So she's got a lot on her plate right now, and I appreciate all your good wishes for her. So we have Jen with us tonight. Thank you so much, Jen, for jumping in. I appreciate the fact that you're so willing to jump in sort of at the last minute usually, and help us out on the moderating. So I appreciate that. And for those of you who don't know me, might be new to the channel, please pop out and subscribe. Hit the like button. It really does help with the algorithm. My name is Lori Hellis, and I am a retired criminal and family attorney. And I'm writing this book about the Lori Vallow and Chad Daybell story. And once a week, we cover true crime, what's in the news, and we do some deep dives. I have a newsletter where I do deep dives into legal issues for those of you who are legal wonks and want to get down in the weeds with me. We do that. I would say the newsletter hasn't been quite as active recently because we have not had a lot of legal developments in the Vallow Daybell case, which is what we've so far been following. But I think the newsletter, as we move into the publication of the Vallow Daybell book, I think the newsletter is going to get a bit of a facelift, and we're probably going to be talking about the legal issues in other cases as well. So to kick that off, I want to talk about, I've got a list. It's actually more than 10, but we'll do our best to get through 10, and then we'll see where we're at. But I do want to chat about a few of the cases that we followed in 2023. So first, of course, I want to talk about Vallow Daybell. Now, those of you who are maybe not familiar with the case, Lori Vallow and Chad Daybell were accused of murder for allegedly murdering, in Lori's case, it's been proven, Lori's two children, JJ Vallow, who was 7, and Tylee Ryan, who was 16. They were also accused of murdering Tammy Daybell, who was Chad Daybell's first wife. And Lori has been accused in the state of Arizona. The charges for Tylee, JJ, and Tammy Daybell all arose out of Idaho, Rexburg, Idaho. Lori Daybell's trial happened in Boise, Idaho. There was a change of venue to a larger location because Rexburg, Idaho is a very small rural community. So Chad Daybell's trial is on those charges, the murders of JJ, Tylee, and his wife, Tammy, are scheduled for it. That trial is scheduled here in Boise. I live here in Boise. Here in Boise on April 1st. Jury selection is going to start the week before, the last week in March, and then the trial will begin on April 1st. Chad Daybell is facing the death penalty. The death penalty was taken off the table for Lori, and essentially that was done as punishment to the prosecution for their failure to provide all of the discovery materials as the law required them. Lori Daybell had not waived her right to a speedy trial, so the judge was unable to postpone her trial and give her extra time to look into and investigate the new discovery materials. So instead, the judge, sorry about that. I was just going to take that off the screen for a while. So instead, the judge severed the trials, allowed Chad extra time, almost a year actually of extra time to do investigations and to prepare for trial. And Lori Vallow went to trial as scheduled in April of last year, 2023. Her trial lasted about 6 weeks. It took the jury about 7 hours to determine her guilt. She was sentenced to 3 consecutive life without parole sentences. She was transferred to the women's prison in Pocatello, Idaho. And about 3 or 4 weeks ago, she was extradited from Idaho to Arizona to answer charges in the conspiracy to murder Charles Vallow, who was her 4th husband. Charles Vallow was shot and killed in what was claimed to have been an incident of self-defense by Lori's older brother, Alex Cox. Alex Cox then later himself died under somewhat suspicious circumstances, although the the medical examiner there ruled it natural causes. It's interesting that there have been a number of people who are associated with the case who have died of asphyxiation or of some sort of pulmonary blood clots, blood clots in the lung. That was the official cause of death for Alex Cox. It also was the official cause of death for a longtime neighbor of Chad Daybell's, who was sort of a nosy guy who was always wandering around on other people's property, and as well as some suspicion that it may have played a role in Tammy Daybell's death as well. Now, the medical examiner ruled that Tammy Daybell's death was due to asphyxiation, and it appears from the medical examination that she may have been suffocated. So that brings us to Chad Daybell's trial. Chad Daybell is still facing the death penalty. It was not dismissed as to him. And so his trial is anticipated to take longer because death penalty cases are tried in 2 phases. First, there is a guilt or innocence phase where the jury determines whether or not the person is guilty. And then once that happens, that same jury will be presented information and will decide whether to impose the death penalty or whether there are mitigating circumstances that would justify a life without parole sentence instead. So those things are coming up. And we also know that Lori Vallow's trial in Arizona is also scheduled in early April. However, in Arizona, there is a provision that allows the prosecution to request that the court designate a case as a complex case to allow the prosecution additional time to prepare. So it means that the speedy trial window gets expanded to 270 days. I expect that that is going to happen because we know that between Arizona and Idaho, there are terabytes, something like 20 terabytes of information that needs to be investigated and prepared for a trial. So I don't really expect that Lori's trial is going to happen in April. That's when it's scheduled. But I think we are looking more toward the fall of 2024 before we see Lori go to trial. So Lori is in Arizona. There is as far as I know, everything that I have seen is that she will remain in Arizona until those charges are resolved one way or the other. Either she goes to trial or there's a plea entered. It is possible that she could decide to take a plea. And there may be some sense in doing that. She has filed an appeal on her case. And so she asked for a new trial. That motion was denied. And so, but there is an appeal pending. So we'll wait to see. But appeals take a long time. It could be 2 or 3 years before an appeal gets decided. So I wouldn't hold my breath for the Idaho appeal. And I think that she will have dealt with the Arizona charges long before that appeal comes up in Arizona. So we're anxiously waiting for Chad's trial. There were a few motions filed in Chad's trial before Christmas that the judge took up and made decisions on. One of the things that John Pryor, Chad's attorney, asked for was to change venue back to, the prosecution asked, not Chad's attorney. The prosecution asked to move the trial back to Fremont County, which is the neighboring county next to Rexburg. Chad Daybell's property was located just across the county line in Fremont County. Rexburg is in Madison County. So the charges were brought because the children's bodies were found in Fremont County. So Chad is being held in the Fremont County Jail, which is a very small jail attached to the old-fashioned courthouse, and his trial will happen in April. The prosecution asked that the trial be moved back to Fremont County because moving the entire trial with court staff and security staff, and I mean, it's a tremendous expense. But the judge said that even though it was a tremendous expense, the likelihood of being able to seat an unbiased jury was much higher in Boise than it would be in Rexburg, because Rexburg is a very small community. According to everything that we know from census data and LDS Church data, the population in Fremont and Madison counties are somewhere around 90% members of the LDS Church. Now, we know Chad and Lori were both members of the LDS Church, and that may very well be a double-edged sword for them, because it's hard to know whether people who are active members of the church would be angry with them for putting their faith in such a bad light. If I were the defense attorney, I would not want a jury of people from the LDS Church for that reason, because I would be concerned that that a jury would be upset with Chad and Lori because of the way that they played kind of fast and loose with LDS doctrine. So we will wait to see what happens in April. The venue will not change. The judge essentially denied all the other motions the defense had filed, having to do with motions to dismiss and some other motions, including a motion trying to lock the prosecution into a prosecutorial theory by saying, you argued that Lori was the mastermind, now you can't argue that Chad was. The judge rightly said, no, I'm not going to limit the prosecution, because remember, this case at its heart is a conspiracy to commit murder charge. The state admits they do not know who actually committed the murders, who actually put their hands on any of the 3 victims and caused their deaths. But there's ample information that there was a conspiracy between Lori and Chad and Alex Cox, Lori's brother. So what the prosecution has said is, in a conspiracy, one person can be the mastermind 1 minute and it can be somebody else the next. That's kind of the nature of a conspiracy. And so being locked into it always being Lori being the one who was the mastermind is an inaccurate way to present and an improper way to present a conspiracy. The judge agreed and declined to issue that limiting order. So what the defense had asked for was a motion in limine. In limine, INLIMNE, Latin, some of the Latin terms that we still use in the law. And in limine really just means an evidentiary ruling ahead of trial that makes a decision on things that are limited in how and when they can come into the trial. So the judge said, no, I'm not going to put the prosecution in a straitjacket like that. They get to put on their case, and they are not limited to a theory that says Lori was always the mastermind, because in a conspiracy, that decision-making or that influential position can rotate among the conspirators. So we wait to see what's going to happen. For those of you who have been interested in my book, all but 2 chapters are going to go to my publisher in the next few days, and then there will be some updates. Some chapters will be updated, and I'll be adding a couple of extra chapters having to do with Chad and the final disposition of those charges in Idaho. and perhaps Arizona, depending on whether or not Lori actually goes to trial. I suspect, I would say there is about a 90% chance that she will not go to trial in April. And my book needs to be going across the publisher's presses no later than the 1st of June. And we're going to start pre-sales right around that 1st of June mark. And you can expect to see it on the shelves in September. So as long as we're able to keep that production schedule, I think things are going to be well underway. So stay tuned for more information as we move along. The next case I want to talk about is the Murdaughs. Now, y'all know Alec. Y'all see, I've been watching too much South Carolina court proceedings. So you know that Alec Murdaugh is a disbarred South Carolina lawyer from a dynasty of family of lawyers, and most importantly, a dynasty of solicitors, which are their equivalent of a district attorney. And so Alec Murdaugh was a volunteer solicitor, and I think he was 3rd, if not 4th generation. His family also founded a very well-known and probably very powerful law firm in South Carolina as well. So Alec Murdaugh was accused of murdering his wife and his son at their property in their hunting property, their rural property called Moselle. And he was tried and convicted. He was one of those guys whose hubris, whose ego meant that he absolutely had to testify. He also was accused of a huge number of financial crimes, of stealing from clients, stealing from misappropriating funds from the bank, and a lot of other financial wrongdoing to the tune of somewhere around $8 to $10 million. Nobody knows where that money is yet, but I think if anybody's going to find it, it's going to be Mandy Matney and Liz Farrell from what used to be called the Murdaugh Murders podcast, is now called True Sunlight. And they also have a companion podcast called Cup of Justice, where they talk at length with Eric Bland, who is a local lawyer and who has a lot of insight both into the cases, represented some of the victims, as well as insight into the legal community down there. So highly recommend. Mandy Matney's podcast is called True Sunlight, and the companion is called Cup of Justice. We'll drop those in the show notes so that you'll be able to grab those links. So Alec Murdaugh was convicted of murdering his wife and son. They filed a request for a new trial that was denied. He has some appellate issues pending, and then, lo and behold, there's an accusation of jury tampering. So the jury tampering accusation arises from jurors who admit or have reported that they had conversations with the clerk of the court, Rebecca Hill, also known as Miss Becky. Rebecca Hill is the clerk of the court. Colleton County is a very small rural area, and it is a small rural county court. Miss Becky ran the courthouse during the Alec Murdaugh trial, and by all accounts, she did a pretty good job. Within weeks of the trial being over, she self-published a book about behind the doors of justice, about what was going on behind the scenes of the Murdaugh case. Well, as you can imagine, that got Alec Murdaugh's attorneys, Dick Harpootlian and Jim Griffin, who I affectionately call Pootie and the Grifter, because I don't have a tremendous amount of respect for either one of them. They are very old school, misogynistic lawyers, and I don't think they did not treat witnesses respectfully, and I think that they have shaded the truth, I will say. So they have accused Miss Becky of improperly influencing the jury. Now, there's a lot of discussion on both sides about whether or not this misconduct with the jury actually happened, and whether, even if the comments were made, if they had any influence on the jury. So one of the legal issues, which is getting a little in the weeds, is what's the legal standard when a judge is trying to decide whether or not juror misconduct occurred. So the prosecution says you have to be able to prove that it impacted the juror's decision, that something that Miss Becky said impacted the way the jury viewed the evidence and had some sort of effect on their decision. The defense says, oh, no, the case law says the judge only has to agree that it could have had an impact on the juror. Either way, the defense is trying to get a new trial. They're trying to get another bite at the apple. And of course, the prosecution does not want to go back and retry this case. They already got a conviction. They don't want to go back and have to do that again. So there is a hearing that's going to be set shortly, an evidentiary hearing. Now, to make things even worse, Judge Clifton Newman, who was steady as a rock, patient, he is a really good judge, very wise, very educated, very measured. And every lawyer who watched that trial was incredibly impressed with him, myself included. And he's edging on to retirement, although he had already told the state Supreme Court that he would, even in retirement, he would continue to stay on the Murdaugh case until all the issues were resolved. Judges can do that because oftentimes what happens is judges who retire are brought back in a senior capacity. Now, in my home state, in Oregon, judges could retire at a certain age, but if they retired at the minimum possible age, they had to commit to coming back as a senior judge for so many hours each year to fill in for judges who were on vacation, or to fill in places where you needed to bring an outside judge in because it's a small town and there's too many people that are connected with the case or the defendants. And so Judge Newman had said he was going to stay on as a senior judge to make sure that all of the issues in the Murdaugh case were decided. However, Pootie and the Grifter then said, but Judge, you might be a witness. We may have to call you as a witness about what you and Miss Becky talked about, or what you told Miss Becky to do. And so Judge Newman has recused himself from the murder trial. Now, he did not recuse himself from the financial crime cases because there were a number of both criminal and civil cases that have been filed having to do with the financial crimes. So he remains the judge on the financial crime issues, but he has recused himself on the murder case. And the state has now appointed the former Chief Justice of the Supreme Court. She is 80 years old, retired, and has been appointed. And the pundits down there are mixed in how they feel about that. On one hand, she was a legislator at one point before she took the bench. She was a state legislator. And she was on the appellate court and then on the Supreme Court, and then ultimately became the Chief Justice. She was the first woman on the South Carolina Supreme Court. And but she also has a lengthy history with the Murdaugh family, because everybody in South Carolina that is involved in the legal community or in the legislature has some level of connection with the Murdaugh dynasty. So there's some very mixed feelings about this judge. I think her name is Toller, but it's a hyphenated name and I don't have it right off the top of my head. I'm sure somebody will put it in the chat though. But there's some mixed feelings about whether or not this is going to be a good change for the Murdaugh case. Now, the prosecution absolutely does not want to retry the case. To add to the complications in this case, Miss Becky is now the subject of an ethics probe. Now, the ethics probe is completely separate from the issue of the jury. The ethics probes have to do with some questions around how she conducted herself before and after the trial. Oh, squeaky wheel. I did see that, and I will comment on that as well. I was just looking at it before I came on. So thank you, Jen, for posting that, and I will comment on it. Remind me, and we'll repost that when we get to taking questions. So Miss Becky's problems have multiplied, and here's where it gets kind of sticky, because they started out answering these issues about jury tampering by saying Miss Becky is a pillar of the community. She is above reproach. She is an officer of the court. She is, and really kind of putting her up on a pedestal. Well, now we have these things that have come out that sort of indicate that maybe Miss Becky is not as squeaky clean as everyone thought she was. So we have these ethics complaints that have gone to the state ethics board. Now, they are not criminal charges. They are not, although the ethics board has asked South Carolina Law Enforcement Division, SLED, which is their state police, to investigate further. In addition, Miss Becky's son was the IT manager for the courthouse. He's been brought up on charges of wiretapping, and it is at least suggested that he did those wiretappings. He was listening in on other people's communications at Miss Becky's request. So there's a lot of fishy stuff going on that puts Miss Becky's integrity and her credibility at risk. Here's the other thing. As things went along and there were questions about Miss Becky, the way that Miss Becky had conducted the courthouse during the trial, Will Folks from Fitz News, which is a digital news organization in South Carolina, put in a FOIA request and asked for all of Miss Becky's official emails. Well, she's a state employee, and the state turned all those over to Will Folks, thousands of them. And within them it was discovered that a substantial portion of the introduction to her book was plagiarized from an article that was written by someone from the BBC. In these days of artificial intelligence being able to take a block of text and go out to the internet and compare it to everything on the internet, it is mystifying why anybody would be plagiarizing. But it's very convincing evidence that she, in fact, plagiarized part of her book. So, once again, even though these things have absolutely nothing to do with whether or not she made untoward comments to the jury before and during their deliberation, it calls her credibility into question, and it gives the defense ammunition to say, yes, but if she lied about where she got the material for her book, if she lied about the fact that she took money to give courthouse tours, if she lied about those things, what else did she lie about? Did she lie about not having those conversations with the jurors? So that is, it is a mess. It is an almighty mess. And so, I mean, there's so much more going on. There are news organizations that are trolling one another, posting stuff on Twitter and Reddit that call each other's integrity into question. It's awful. It is absolutely a cluster down there, and it is only going to get worse. So it's, from a legal standpoint, it's fascinating. From a cautionary tale standpoint, it's fascinating. It's so disheartening to see our judicial system in our country, based on our Constitution, trampled for personal interest. And it's incredibly discouraging to see that happen. I hope that all of this attention that's being given to South Carolina is going to have the disinfecting effect of sunlight, that we are going to get, that things are going to get disinfected and cleaned up. But it's an ugly system down there. One of the biggest problems down there, in my opinion, is the fact that their judges are not elected. They are appointed by a committee of legislators, and all of those legislators are lawyers. And all of those lawyers are doing the, we'll appoint you if you scratch my back, I'll scratch your back. Well, I will appoint you. But remember, judge, once you're a judge, we're going to expect you to give us something back. And that's how those judges get appointed. And that should be incredibly alarming to anybody in South Carolina. Whether you are facing the judicial system or not, we all know that we are one complaint away from being brought before a judge, right or wrong, innocent or not. And it's only the strength of our system and the way we test the state's evidence that protects all of us. And so if we have defense attorneys and judges who are in bed together, that's a dangerous, dangerous road to go down. And they've been there a long time. So there is a move in South Carolina to change that, but I don't think it's going to change soon or easily. So that's definitely something to watch. There are so many tentacles that have come out of the Murdaugh case. It's a fascinating story in and of itself. There are going to be books continuing to be written about the Murdaugh case for years to come. So stay tuned. I don't think I'm interested in going there, but there are a couple of other stories that we're going to talk about tonight that I am acutely interested in. So one of those is the Delphi case. And I want to move on to the Delphi case. Now, there's not a lot going on now, but I do want to do a quick recap. The Delphi case had been languishing essentially with no arrests since 2016, sorry. And with the murder of two young girls in Delphi, Indiana, and in a park where they'd just gone out for a hike. And kind of surprisingly and out of the blue, Richard Allen was arrested. He was a pharmacy technician at the local Walgreens or CVS, one of the two, and he was arrested. And as time went on, it became clear that the probable cause for arresting him was thin. He had two very good, very zealous attorneys who worked very hard, and they came up with some alternate theories. Now, they're a little woo-woo, but they're not without possibility. They're not outside the realm of possibility. And so the theory is that the two girls were murdered by a group that are what they refer to as Odinists, people who are followers of a Norse religion that includes Odin as one of in the pantheon of their gods. And further, that people within the prison where Richard Allen is being held, and he's being held in prison, not at the local jail, because the judge agreed that the local jail couldn't keep him safe. So he's being held in the prison. Odinism is a form of religious observation that is used it is common in prisons, and particularly common among the white supremacist movement in prisons. So they have regular Odinist services in a lot of prisons. So Richard Allen's attorneys claimed, and they filed a 137-page motion and brief claiming that there was an improper representation made to the court to get the probable cause, to get the warrants. The probable cause affidavits did not disclose these alternative theories or these alternative suspects. And so the judge signed warrants and allowed the police to arrest Richard Allen and search and seize his property. So the two attorneys filed a challenge to the probable cause affidavit and the warrants. And if those things were thrown out, if the court found in their favor, then Richard Allen essentially would be free. So, but Judge Fran Gull, who was the appointed judge in the case and was a senior judge who had been appointed to that particular case, decided that the two attorneys were acting with gross negligence. What happened was one of the two attorneys had the discovery in a locked conference room, or in a conference room that could be locked. When an old friend of his who had previously shared office space within his office dropped in. The attorney was on the phone, and the guy sort of made himself at home, including going into the conference room where all of the discovery on the Delphi case was located, and snapping pictures on his phone of some of the crime scene photos. That person then sent them to someone else, who then distributed them to a couple of YouTube creators. Those YouTube creators promptly called police, turned them over, said, "We don't want these, and you need to know that somebody out there is distributing them." The person who took the pictures was charged with essentially with theft, and the person who distributed them committed suicide. So it was an awful case. Yes, the discovery material was left in an unlocked space, and the person made their way into it. They were, however, trespassing. They were not invited to go and look at the discovery. Judge Gull, however, found that that was gross negligence, and she removed both lawyers from the case. Now, there are an awful lot of people, including Bob Mata from Defense Diaries. If you're interested, he's a great resource on Delphi, who believe that Judge Gull did it as a way of removing them and that defense from the case. She didn't like that they had. One of the things that she was upset about was the fact that that 137-page motion released information to the public that had previously not been made public. And she was not happy about that. So it's interesting that it all kind of happened at the same time. And it was suspicious, very suspicious. So the attorneys have filed motions with the Indiana Supreme Court asking to be reinstated. And the judge essentially knocked them out, said, you're not on the case anymore. You can't file anything in this case anymore. You can't. And so they kind of had to do some legal moving around and convince the Supreme Court to hear their appeal prior to trial. And the Indiana Supreme Court agreed to hear the case. They're going to hear oral arguments on the 18th of January. And we have heard that they're going to be live streamed. Not all Supreme Courts allow live streaming, so it'll be interesting to see how that all plays out. But I'm very anxious to see what's going to happen on the 18th of January and whether or not these lawyers are going to be reinstated, because Judge Gull appointed some hand-picked lawyers from her jurisdiction to represent Richard Allen. Richard Allen doesn't want those guys. He wants the guys who believe he is innocent. And I have to say, with what I know from the probable cause affidavit and the information that was included in the 137-page motion, which I read, I have to say that I believe that there is reasonable doubt and that there may not have been probable cause for those warrants. I believe that the probable cause for those warrants was incredibly tenuous, and I think that that a different judge may have come to a different conclusion about whether or not there was probable cause. So I'm anxious to hear what's going to happen. So another case that we talked a bit about was Caitlin Armstrong. I'm not going to spend too much time on this case. Y'all watched her trial. She was convicted, and then decided to make a quick dash for the fence after a medical appointment, which was pretty darn amusing, in her black and white striped jail garb. She has a reputation of fleeing. When she was questioned about the case before she was arrested, she took off for Costa Rica. She had plastic surgery while she was there to alter her appearance. She clearly had a motivation to try and avoid capture. And of course, now she's got an attempted escape on her record as well. So she'll probably be spending a few extra years in jail. She essentially has a life sentence already, so I don't know. She probably felt like there wasn't much to lose. However, she is going to remain in jail. Another development that happened this year was the final resolution of sorts for the Natalie Holloway case. Natalie Holloway was a young 18-year-old who went on a high school graduation senior trip to Aruba, disappeared in Aruba, and her mother has been seeking closure about her disappearance ever since. There was a young man, young at that point, named Joran Vandersloot. He was a immigrant from Holland, and he was always suspected of having been the last person to see Natalie alive, but there was never enough evidence to try him. He then hightailed it out of the country and moved to Peru, and within another year, on the anniversary of Natalie's disappearance, beat a woman to death in his apartment. He was convicted of that murder and sentenced to life in prison there. In the process, he also reached out to Natalie Holloway's mother, Beth, and told her that he would tell her what he did with Natalie's body in return for money. She and the government played along and were able to bring him up on charges of extortion. He was extradited back to the US, and in a plea agreement with the United States authorities, agreed to honestly recount what happened to Natalie Holloway. He gave that information in open court to Natalie's mother and essentially admitted that he bludgeoned her to death and that he disposed of her body in the ocean. So her body's never been discovered, and but I hope and pray that after all these years, Beth Holloway was able to finally have some closure and to know that Joran Vandersloot is in prison for the rest of his life. And I suspect that Peruvian prisons are probably not as pleasant as American prisons. So, but that foreign connection also leads us to another one, and that's Lindsay Shiver. Lindsay Shiver was a college cheerleader, beauty queen, married the college starting quarterback who did a brief stint in the pros, is the son of a very, very wealthy family in Georgia. And his family owned a home in the Bahamas, a vacation home, and they would fly in their private jet out to their vacation home. Well, Lindsay often flew out on the private jet and to the vacation home in the Bahamas and met a young man who was the bartender at the local watering hole and had an affair with him. When the husband found out, he filed for divorce, which was very contested, unhappy divorce. He filed for custody of their 3 young children. And she then is alleged to have enlisted she and her lover are alleged to have enlisted a 3rd man to murder her ex-husband the next time he was in the Bahamas at the vacation home. Fortunately, there was a robbery at the watering hole where the boyfriend was the bartender, and local Bahamian law enforcement were looking at everyone's telephones because they felt it was an inside job, as they often are. And as they were looking through his telephone, they discovered a whole bunch of messages having to do with a plot to murder Lindsay Shiver's husband. So they were arrested. They were brought back to Nassau because the only jail/prison on the island is Fox Hill Prison, and it is every year listed as one of the worst, top 10 worst prison conditions in the world. It is abysmally filthy. There's no running water in a lot of portions of it. There are just bars on the windows, no glass. It is vermin infested. The food is nearly inedible, and if you don't have family who can bring food and bribe the guards to give it to you, you don't eat. The conditions are horrific. Well, that's where Lindsay Shiver was. She was there for almost 2 weeks before she was given bond. But a term of that bond was that she had to remain in the Bahamas. So her family has been footing the bill for her to live in a short-term rental somewhere with an ankle monitor. And just before Christmas, her attorney filed a motion requesting that she be allowed to leave the Bahamas and go to the US. Now, there was no clear idea of how long she was going to be allowed to remain in the United States. She asked to be able to go for the holidays so that she could see her children. It's unclear whether she saw her children or not. She is living with her parents, and she's still on an ankle monitor. But it is pretty shocking that the Bahamian authorities allowed her to leave the country. The Bahamian system of justice is very different from that in the US. It's much more, they were a British colony, so it's much more like British Crown rule. And I'm not sure if she had not been a white socialite, that she would have gotten the same treatment. So it will be interesting to see what they do in the Bahamas, whether or not there's a plea, whether or not she will ever go back to the Bahamas to stand trial, and if so, when. And of course, we have Rex Heuermann. Rex Heuermann has been labeled as the Long Island serial killer. He has been charged with 4 of a large number of murders that happened in Long Island. And he is currently being held in jail. His next court appearance, I don't think, is until sometime in February. Interestingly, his wife has signed a deal with, I believe it's Peacock or Paramount, I can't remember which, network, for $1 million. Now, she cannot benefit if it benefits him. However, she did not sign the agreement to provide them with, to participate in the documentary. She signed an agreement to give them access to her family photos and family records. So I think we're going to see a documentary come out about Heuermann and about his family in fairly short order. And I don't know how I feel about this. There's absolutely no indication that that his wife, whose name is Asa, was in any way involved. At this point, we have no indication that she was in any way involved. They had 2 children. She has a son with disabilities who is dependent on her, and an adult daughter. It was quite clear from the beginning that she did not have access to a lot of money, that he controlled the family money, and that she was in pretty dire straits. At one point, she petitioned the court and asked them to release Heuermann's collection of guns so that she could sell them because she needed money to live. So I'm not really sure how I feel about this. On one hand, I think she may be a victim. On another hand, I don't necessarily love that she's profiting from people whose loved ones truly were victims. So I guess I'm waiting to see how that develops, and whether or not what role she will play in the prosecution. I think it will be a lot easier for a lot of people to swallow if she is extremely cooperative with the prosecution and law enforcement. I don't know that we know enough at this point, and let's remember law enforcement is playing this all very close to the chest vest, because there's a lot of information that they do not want to make public. This is really very much an ongoing investigation, and there are many, 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 many more victims. So I think that law enforcement is trying really hard not to compromise their investigation in any way. But it will be interesting to see what her role will be in the investigation. I think public opinion is going to be a lot more supportive of her if she is, in fact, blameless and essentially is a victim as well, and if she is very cooperative. So, but we don't know a lot more about that case. We know he's in jail. We know that he has a lawyer. We know that it was announced that she had some communication with him. She may have visited him, and we know that that the police are still doing a very broad investigation. So, and on to Brian Kohberger. The big news out of the Kohberger case: Brian Kohberger is the man accused of murdering 4 University of Idaho college students in Moscow, and he has been in custody now about a year. He has waived his right to a speedy trial. There have been a number of motions that have been pending and have been heard. The judge did decide that he will allow the trial to be live streamed. And at this point, the trial is set in the fall of 2024. It will be interesting to see whether or not that actually goes. The state has sought the death penalty. It is another small, fairly rural community. I would not be at all surprised to see a change of venue motion. And that could mean there could be another very high profile case in the Ada County Courthouse in Boise. If that's the case, that in itself could cause some delays. Because remember that the Ada County Courthouse has their own full docket and have had to play host to the Vallow Daybell cases as well. So if there is a motion to move that trial, which would not surprise me. In fact, I'd say it will surprise me if they don't file a motion to move. And if that happens, then I think it could be perhaps even into next year before that case gets scheduled, because we know what a huge burden it puts on everyone to have one of those high-profile cases, both the court and all of the people who are involved. We heard at length the prosecution complain about the expense and the hardship of having to move for 6 weeks to a different city and conduct a trial of that magnitude out of a different city. It's a lot. So it will be interesting to see. One thing we do know is that the home that was the crime scene was demolished a few days ago. That had been sort of up and down and in the air for a while. The landlord who owned the property, donated the property to the university. While at first that may have seemed like a generous thing for that person to do, the problem was that as long as the property stood, there had to be around the clock security on the property. And it became a place that people wanted to visit, they wanted to go see. It attracted a lot of attention, and it was a financial hardship for the university. So the university said, we want to tear it down. Initially, both the prosecution and the defense said, you can tear it down. We have everything we need. Then there were some last minute jockeying around about, well, maybe we don't. And there were some last minute, we want to go back in one more time. And I think a lot of the victims' families expressed some deep concern about whether or not the prosecution might be compromised because the jurors couldn't be taken to the location. Now, I will say that my experience has been that jury views are not necessarily very constructive. Case in point is the Murdaugh case. A few days into the Murdaugh case, Murdaugh's attorneys filed a motion with the judge asking for the jury to be taken to the crime scene. I think that was very ill-advised on their part. I think that anytime you put a human being who needs to make a decision about someone, about the truth or the veracity of evidence, you put them in that place, it hits different. It is very, very different to stand in the doorway of the feed room where Paul Murdaugh was shot than to look at it on screen in pictures. And I think that it always hits, it disadvantages the defense. So I thought it was very foolish on the part of Harpootlian and Griffin to press to take the jury out and on scene. No matter how accurate the photographs and the measurements and all of the 3D modeling is, it's still different to stand in that physical space and to know what occurred on that physical space. It has an emotional impact that that doesn't occur when you are using photographs and 3D modeling. And believe me, the scene was horrendous enough. The photos, the 3D modeling, all of that was heinous and horrendous enough. But it feels different to actually stand in that space. For anyone who has ever visited a monument, a Civil War battlefield, concentration camps in Europe, you know that there is something different about the feel of a place. So I think it would be, I think it was a mistake in Murdaugh, and I don't think that it is going to hurt the case in Kohberger. I don't know that it will make a difference one way or another. But the other thing is that it does raise issues on appeal. I think the first thing that the defense does is start filing motions saying the jury was unduly influenced by being physically in the space. Now, in the case of Murdaugh, they're going to have a real hard time saying that because they were the ones that asked for the jury view. But in a case where the prosecution's asking for a jury view, I think it does set up some appellate issues. So I frankly don't believe that demolishing the house is going to have a huge impact on the case. And I think that it staves off some appellate issues. So moving on, let's talk about Corey Richins. Corey Richins is the Utah mother whose husband was killed by an overdose of fentanyl. She is also the mom who then wrote a book, a children's book on helping children cope with the grief of losing a parent. It came to light that she had made some very ill-advised investments on homes that she wanted to flip, and that she and her husband were in disagreement about those investments, that she was in pretty dire financial straits with those business arrangements and obligations, and he declined to underwrite them. So she took him a drink, and he died of fentanyl poisoning. She has been accused of, as well, of witness tampering, for writing letters to her mother and her brother, appearing to solicit them to lie under oath about her husband's behavior, to tell people that he used to go to Mexico to get drugs, which there's no indication he did, and a number of other things. The court declined to issue an order saying that she could no longer have contact with her mother and her brother, but the prosecution is still mulling over the idea of filing witness tampering charges. There is no new court date set, because now she sent a whole envelope of documents to her lawyers marked attorney mail or confidential information, and the prosecution is challenging whether or not that information is privileged, and so there likely will have to be an ongoing investigation. So she has claimed that some of the information was protected by attorney-client privilege, some of the information that was sent out prior, and that some of the current information is also protected by attorney-client privilege. So the judge is going to have to appoint an independent third-party attorney who will assess all of that information and tell the court whether or not what portions of it should be released and what portions cannot be released because they are attorney-client privilege or work product. Work product is things that an attorney does in their office to prepare a trial. So, for example, if I'm getting ready for trial and I'm making all kinds of handwritten notes, my handwritten notes are work product. They are not discoverable to the other side. If I research a case and I print it out and I make notes in all the margins and talk about my trial strategy and how that case relates to my trial strategy, that's not discoverable as because it's my work product. So an independent attorney at this point is going to have to review all of that information and give the judge a reading on what is covered by work product and what is not, or what is covered by attorney-client privilege and what is not. So it could be some time before trial finally gets set, because that process is going to have to play out, and that could take weeks. So the judge has to identify someone, they have to accept the responsibility, then they have to review everything, then they have to respond back to the court and all the lawyers. And so it could be a fairly lengthy process. So no trial date set yet. A lot of folks asked me about Chad Dorman. Chad Dorman was the man who is accused of murdering his young children, his 3 little boys, and he was taken into custody that morning, sitting on his front porch with a rifle. His his wife was also injured, shot through the hand trying to protect the children. It's a horrible case. I think that there is a lot of information flying around, a lot of evaluations being done about his fitness. There are going to be evaluations done on whether or not he was sane at the time that he committed the crime, as well as evaluations on whether or not he is currently able to aid and assist. Both of those can be at issue. My understanding is that there are 41 pending motions in the case right now. And what that tells me is that there is a lot to be decided pre-trial. There is a trial set for July 8th at this point, but with 41 motions pending, I think there's only about a 50-50 chance that that is going to happen. So Ruby Franke and Jody Hildebrand. These are the folks from Utah. Ruby Franke was a mommy blogger. She had a YouTube channel called 8 Passengers about parenting a large, presumably LDS family. She then took all of her followers over to her and got involved with a woman named Jody Hildebrand, who had been her therapist. And they got involved in Jody's undertaking called Connections, which was a site that sold self-help seminars and self-help content, including parenting. 2 of Ruby Franke's children were found in the basement of Jody Hildebrand's home. They had been physically restrained, physically abused, punished, and to the extreme. And one of the 2 children escaped, went to a neighbor's home, asked them to call the police, asked them for help. And the police recovered both children. Ruby and Kevin Franke had 4 children who were still not adults. The 2 oldest, I believe, at least one of the eldest children is an adult. I think they both are, the 2 oldest. So the 4 youngest are in state protective custody, and both Jody Hildebrand and Ruby Franke entered guilty pleas just on the 28th of December, so just after Christmas last week. They both entered guilty pleas to 4 of the 6 charges, and sentencing for them is set for the 20th of February. Pre-sentence investigations are being done, and the 20th of February, those sentences will be handed down. The minimum that they could get on each count is 1 year, and the maximum is somewhere around 15 years. So I think it's unlikely that they will get 15 years on each count, but I think that it's also unlikely that they'll only get a year on each count. If I had to predict, I will predict that they will get enough time so that all of the Franke children will be well into adulthood before they're eligible to be released. That would make perfect sense. If I were a judge, that certainly would be what I would be looking at, would be looking to make sure that the children who were involved had the best possible chance of healing and launching into adulthood before they had to deal with their abusers being out of custody. A lot of you are interested in the Dee Warner case. This is a case where Dee Warner disappeared. Her children believed that her current husband, Dale, was responsible, but her body has never been found. And her children, in an attempt to, because they wanted to hold Dale responsible, and prosecutors were saying there wasn't enough evidence to arrest him, they petitioned the court to find her, to classify her as legally dead so that they could bring a wrongful death suit. In the meantime, Dale Warner has been arrested and is being held on a $15 million bond. And there was supposed to be a probable cause hearing held on December 5th. It was bumped out, and I couldn't find any information about what happened to that postponed probable cause hearing. It was bumped out initially because there was so much discovery. I suspect it's been bumped out again. There is an examination of evidence hearing that's set for March. So I'm not quite sure in that jurisdiction what that means, whether or not it is a hearing to determine whether the prosecution has turned everything over or whether it's a probable cause sort of hearing. But I will keep an eye on that, and we will talk more about it. And finally, I want to talk about Adelson. So Adelson is fascinating. This is a case that really piqued my interest for a number of reasons. For one, I think there are some really interesting parallels with the Piketon massacre, both of them having to do with domineering mothers, matriarchs, who wanted their grandchildren. So I think there's some really interesting parallels there that I'd love to dig into. The very idea that you have a matriarch grandmother who has that much control over a family that she dictates murder is intriguing and interesting. And you all know I like those cases that are very multi-layered. So it's one that's certainly on my radar for potentially another book. So what happened in the Adelson case, for those of you who are not familiar, the victim was Florida State University law professor Dan Markel. He was grew up in Canada, was in a Jewish family, was a Harvard undergrad and Harvard law graduate, and was a very well-respected law professor and criminal law theorist. He was a brilliant guy. He married a woman who was also a lawyer. He met her while she was finishing law school. He was several years older, so they didn't meet in law school, but he met her while she was in law school. She was also Jewish. They married, and they were married for several years, had 2 little children. When the wife, Wendy Adelson, filed for divorce. Wendy Adelson was from a very wealthy family in South Florida. She had grown up in the Miami area, in the very affluent South Florida, South Beach area. Her father was a dentist who had a chain of dental offices. She had 2 brothers. One became a physician, and he is somewhat estranged from the family. And the other brother is Charlie, and he also became a dentist. He was a periodontist. So Wendy goes through a fairly contentious divorce with Dan Markel. Dan Markel is an incredibly devoted and very hands-on father. They share custody 50-50 between the 2 parents, and he is an extremely involved dad. The children at that point are 2 and 3, or 3 and 4, right in there. And he has them half-time. Wendy Adelson, with the support of her family, and particularly her rather pushy mother, files a motion with the court to be permitted to move from where they live in Tallahassee, Florida, to up in northern Florida down to Miami. It's about a 6 to 8 hour drive. And Professor Markel says, there's no way I'm going to be separated from my children. There's no way I'm going to be a weekend dad. And he contests the move, and the court sides with him and tells Wendy Adelson she can move, but she can't move the children. So it's well known that Wendy Adelson hates Tallahassee. She thinks it's the sticks. She thinks they're all uncultured hicks in Tallahassee. She hates it. She wants to be back in South Beach. So two gunmen of Hispanic descent, one of whom is a head of the Latin King gang, or a division of the Latin Kings gang, drive up north to Tallahassee, and they follow Dan Markel. He drops his children off at daycare. He goes to the gym and works out. And as he is pulling into his driveway, they shoot and kill him in the drive behind the wheel of his car. The neighbor across the street sees a car speed away, reports to the police what he's seen. And then there's a couple years worth of some pretty good police work that finally turns up, working from the Wendy Adelson side and from the gunman side, and the two converge. So they realize that these gunmen have been solicited by a woman named Catherine Magbanowa, Katie Magbanowa, who just coincidentally was at the time Charlie Adelson, the dentist's girlfriend. And she is the one who introduces the Adelson family, namely Charlie, to the gunman and is the go-between. So the two gunmen initially are arrested, tried. Catherine Magbanowa is arrested. She's tried. She's a co-defendant, and at her trial, the jury hangs as to her guilt or innocence. They find the other guy, the other gunman, guilty, but they hang up as to her. The second gunman enters a plea and rolls over on the other two. So now Katie Magbanowa rolls over on Charlie. So Charlie is arrested. He just recently in 2023 finally went to trial, was found guilty, and was sentenced to life in prison. But there were hours and hours of recorded wiretap phone calls between Charlie and his mother that very clearly implicate the mother, Donna Adelson. And so a week after Charlie is arrested or is convicted and sentenced, Donna is picked up at the airport with a one-way ticket to Vietnam, which has no extradition treaty. There are wiretaps continuing where she talks about the fact that they're going where there's no extradition. And she is literally arrested in the jetway getting on the airplane with her husband, Harvey. Harvey is not arrested, but Donna is. And Donna is held in Miami and then transferred down to Tallahassee, where nobody wants to be, where she is being held on murder charges as well. So we still have Donna's trial coming up. And we don't know when that will be. Preliminarily, she's been indicted and she's been arraigned, but the rest of the preliminary hearings have not been set yet. So it will be really fascinating to see where that goes. And as I say, I see some really interesting parallels with domineering matriarchs with the Piketon case. So that is the wrap up. I did want to talk about, and Jen, if you can find that comment from Squeaky Wheel about that video that happened, I think it was yesterday, was a fascinating video. There it is, Mary Kay Holthus in Las Vegas. If you get a chance, I didn't take the time to download the video, and so I don't have it available to show you, but it's all over YouTube. So definitely, I'm sure there are a number of creators that are showing it, but the video footage from the the video feed from the courtroom is there. The judge is Mary Kay Holthus, and it shows her. A guy is before her. He's either been to trial. He's there for sentencing, so he's either pled guilty or he's been to trial. And she is looking over his record, and he is speaking very softly, very trying to be very persuasive. He's talking very gently. He's trying to convince her that he wants another try at probation, that he doesn't want to go to prison, and he is trying to sound reasonable and even, and she's looking at his record, and he's got a lengthy record of robbery and domestic violence and assaults, and I mean his history is appalling. And so she hears from him, she hears from his lawyer, who pitches that she should allow him to do probation and not and suspend his sentence and not sentence him to prison. And she says, I can't do that. I'm looking at his record, and I think it is time that I think what she says is he had a taste of something different. And he launches across the counsel table and across onto the bench. I mean, he does like Olympic high dive, screaming at the top of his lungs, dives into onto the bench and takes her with him down to the floor behind the bench. Fortunately, there is a court security and what appears to be a guy in a suit, a court clerk, a male court clerk, who promptly dive into the melee and pull this guy out. The judge in the video says he hit her hard enough that she hit her head against the wall, and they're asking for medics. So you see them trying to subdue him, and he is screaming and he is out of control, and you don't really see him, but you see the two guys who are trying to subdue her at one point. They're yelling, get off her, get off her. So I don't know whether or not he had attacked someone else as well, but it was very frightening, terrifying. I'm sure the judge was absolutely terrified. When I was practicing in Portland, Oregon, which was a gazillion years ago now, court security was not where it is now. And the only time we really went through court security and metal detectors was if we were, if there was a particular case and they would set up a mobile unit outside the actual courthouse door, if there were some reason for it. But we didn't, as a matter of course, go through metal detectors and security to get into the courthouse. And there was a case where a guy came into court. It was a family law case. And when the judge denied this man's request for custody of his children, he jumped up on the bench, went in. He didn't attack the judge. He went into the judge's chambers, and he had a handgun, and he committed suicide in the judge's chambers. And that was probably the worst I saw. Squeaky Wheel's question has to do with, do I think Judge Boyce should be prepared should Pryor pull such a stunt? First of all, I don't know of any lawyer who is going to pull that kind of a stunt. The guy who attacked Judge Holthus was a defendant, and she was sentencing him to a prison sentence. He was a guy who had a long history of being violent and of violent crime. So I cannot see any lawyer flipping out and physically attacking a judge. I don't see that happening. And I sure as hell don't see Chad Daybell doing it. I don't see Chad doing it. I think Chad is a complete coward, and he is not going to do anything like that. So I don't see that happening either way. But if you do get a chance to see the footage, it is disturbing. And I feel for that judge. She is a woman probably my age, and that was an incredibly frightening experience. Now, you don't get to be a judge without having thought through what would happen if, particularly if you happen to be a criminal court judge. So I'm certain that she's played that scenario through her head before. And I'm certain that she and her staff have talked about what ifs. But you never know until it happens to you. So great question, guys. Really great question. So, hi, Don Schaefer. Yeah. So, when I went to Rexburg, one of the things that I found really moving, this is not the exact tree because we didn't have a good enough photo of it. But I took a photo of the tree that everyone started calling JJ's tree, which was the tree that JJ's grave was under. And I mentioned that in the book. And when I sent it to my publisher, she said, that is so haunting. So she passed along those photos to the cover designers, and this is the cover design that came up from it. I love it, and I love that it honors where the kids were found. Tylee was found not very far away, a few yards maybe from JJ's tree, but it became very symbolic, especially to the law enforcement folks. So I couldn't be happier with it. We're going to mess around a little bit with the subtitle. I don't necessarily like where it is. I think it kind of stops the flow of the title. So we're going to mess around a little bit with that, but that's what essentially it's going to look like, and I love it. Yes, wristbands. You can still get one. If you send me a self-addressed stamped envelope to that address, I will send them out. Now, I admit I have not been to my P.O. box since before the holidays. I need to get over there and pull any requests. But as far up until whatever's in the box, I've sent wristbands out to everybody. There are plenty more. We're going to be giving them out at CRIMECON. We're going to have all kinds of fun stuff to do at CRIMECON. Talking right now about swag. If you order, if you come to CRIMECON and you can show that you have pre-ordered the book, we're going to be giving out goodies, and it's going to be super fun. The book will be available for pre-order, and we will have some sort of a promotion for pre-orders. It'll be available for pre-order on Amazon and at the major booksellers after CRIMECON, the end of May. So the dates for CRIMECON are the 30th of May through the 1st of June. So it's that long weekend. And I have to tell you, CRIMECON gets bigger every year. The Oxygen channel is an incredibly big sponsor. They all have all kinds of stuff. And I'm telling you what, all your favorite creators are there. There is a big room they call Podcast Row, and everybody anybody who is a creator is there. There's an amazing array of people. If you want to meet any of the people that you see on YouTube, CRIMECON is the place to go. This last year, Joel Waldman and Carm were there from Surviving the Survivor. all of the folks from Dateline, from Oxygen, from News Nation, from Long Crime Network, they're all there. And you get an opportunity to visit with them. It's a super, super fun. And there are so many great panel discussions. We've got, I've got a kind of a proposal that we're working on to give out. How many bracelets has my big heart given out? I don't know. Probably somewhere around 1,500, 2,000, somewhere around in there, about 1,500, I would say. Thinking about what I still have left in the box. But, you know, it was never meant to be anything except a way to honor them. And I do want to remind you, it's not too late, because I think it's going to be super important in April when Chad Daybell comes up for trial, when Lori comes up for trial in Arizona, that we flood social media with pictures of us wearing our wristbands. I think it's very important that we continue to show our support for the victims and the families of the victims. And I can tell you that Kay and Larry Woodcock, appreciate it when they see that on social media. We did have one good-sized development happen that I didn't mention in when we were talking about the Vallow Daybell case, and that is that Tylee and JJ's bodies were finally released. I understand from social media that JJ has been cremated and that there are memorials planned, but I don't have any other information about when and how that might happen, whether or not it's going to be private, whether there might be some sort of public memorial. I don't think they've made those decisions. Shortly before Christmas, Tylee's remains were released to Colby. What decisions being made as far as her arrangements, I've heard nothing. And I haven't reached out to Colby to ask. He's had it pretty rough. So I don't know what decisions are being made. I do know that Kay and Larry at one point were hopeful that they could lay the kids to rest together, because Tylee was so close to JJ and they were inseparable. That last picture of them at Yellowstone says it all about their relationship. So I think we'll know more as time goes along. Those are kind of private decisions that the family's going to be making, and I think we'll know more. But the remains were released shortly before the holidays, and that was a hard time to have to make those decisions and those arrangements. So, but I was very happy to hear that. So please get your wristbands, and I'm happy to send them out. Hi, Tennis Girl. Isn't the penalty for not turning over discovery supposed to be the information cannot be used? I've just never understood the remedy chosen. This is a great question. And I appreciate that you guys ask these kind of more nuanced questions. So here's how this happened. Discovery, there are multiple reasons, purposes for discovery. So what the rules say is that the prosecution has to turn over to the defense anything that might either be exculpatory. They have to turn over all evidence, including anything that might be exculpatory. That means that might exonerate the defendant, or might lead to information that they can uncover. So it's not just enough for the prosecution to say, oh, well, we overlooked this thing, we just won't bring it up at trial. That's fine. but the defense has not had the opportunity to fully investigate that information and decide whether that information could lead them to new information that could be exculpatory. Hopefully that makes sense. So what John Pryor argued was, it's not enough for the defense, the prosecution, to just say, we won't bring in that DNA evidence, because it's possible that DNA evidence could lead to exculpatory information. And I don't have the opportunity to have my expert look at the raw data, to have the DNA samples retested if necessary. I don't have the opportunity to do that because I didn't get the information in time, and now trial's looming. So the judge had to figure out a way to equitably give a recourse to the defense. So in the case of Lori, because she had not waived her speedy trial right, the judge couldn't say, Ms. Vallow, I'm going to give you another year to get all that information, have it reviewed by an expert, have it retested if necessary. I'm going to give you all that extra time, because Lori didn't want extra time. She wanted her trial. So the judge had to find a different way, to a different remedy, if you will, a different consequence for the prosecution being sloppy. So the other thing was that he had to sever the trials because the remedies had to be different. Chad Daybell wanted more time. John Pryor wanted more time. He wanted more time to mess around with the DNA evidence. He wanted the information because he wanted to be assured that what the prosecution had not given him, the information, the new information, didn't turn up new or exculpatory kinds of evidence. That is zealous and effective advocacy. That's his job. Because he wasn't up against a time limit, he had the luxury of being able to say, give me all that stuff. I want all of it. And I want the time to look at it and digest it and understand it. But Lori Vallow's team didn't have that luxury. And the judge said it's not sufficient for the prosecution to just say we won't use it. There has to be some other kind of a consequence for not following the rules, not meeting the discovery deadlines. So when the judge did all of that research into other cases, he didn't find any controlling decisions that have been made in Idaho, but he did find similar cases in the federal rules and in other states. So he went through and looked at cases that were similar, had similar fact patterns, and what had been decided in those cases. And he found that there was a basis for dismissing the death penalty as a consequence for the prosecution not having met their discovery burden. So that is the reason why the judge decided to take that off the table, because it isn't just enough to say you can't bring it in at trial. Because even if that piece of information doesn't come in at trial, it could be that it turns up other evidence that could be admissible at trial. And without the opportunity to investigate that, the defense is at a disadvantage. So hopefully that answers that question. Thanks for asking it. Hi, Gail Johnson. If Odinist practices support white supremacy, there should be no one working in the prison system with Odin symbols on their uniforms, which I hear that some of the guards did. Is this so? It is so. It is so that the guards, specifically the guards who were responsible for Richard Allen, were wearing patches on their vests that said, "In Odin we trust." And it is very evident that Odinist practices and the religion, the Norse influenced religions that have a pantheon of gods, are connected very closely with white supremacist gangs in prison. I agree that it has no place with the guards, and that it is incredibly objectionable. And that was the point that Richard Allen's defense team made, was that Richard Allen was being subjected to abuse, being denied medical care, denied his rights, denied humane care, because these prison guards, who were part of the Odinist group, were responsible for him and in charge of him. And that there is some sort of overlap or connection between Odinism within that Delphi community and that larger community, and the prison. So I think, do I think it's a little woo-woo? Yeah. But then, it's not the first time we've heard of cults committing murders. I mean, we do have the Manson murders to kind of hold up as a template. And if someone had stood up and said these innocent people were murdered by cult members, when people stood up and said that, a lot of people totally discounted it as, "You've got to be crazy. This makes no sense." So I think that his defense team certainly has raised reasonable doubt by bringing up this Odin connection. Now, does it mean Richard Allen is not guilty? Not necessarily. But I think that they have raised sufficient reasonable doubt and brought into question the probable cause affidavits that were filed that got the warrants for Richard Allen's arrest and the search and seizure of his property. And if those warrants get thrown out, then law enforcement is going to have to go back and reinvestigate and do the investigative work if they want to prove that Richard Allen is their guy. And I think they took a shortcut. So it will be, from a legal standpoint, it will be really interesting to see what comes out of that court hearing on the 18th. If Richard Allen's attorneys are reinstated, then I think you're going to see a really rigorous defense of Richard Allen and the connection to Odinism. So it's going to be fascinating. Linda Sears. Why was Corey's book taken off Amazon, but not Chad Daybell's books? This is a good question, and I don't know. I think it may be, and I know this is going to seem weird. I know that there are a lot of people who have complained about Chad Daybell's book. And I think Amazon's position was that he had not been convicted, and until he had been convicted, they would not take his book down. However, I think the reason why Corey Richan's book has been taken off of Amazon is because of the civil suit that is going on from her husband's family. So what happened is that his family filed a wrongful death suit. They filed that wrongful death suit and asked the judge to freeze all of the assets that Corey Richens inherited, including life insurance proceeds and book proceeds and all of those things. And the judge issued that order to freeze all the assets. I think that it probably is the reason why, is because they requested that the book be taken down, and they had the power to do that because of the civil suit that's been filed. Because I think there's been a trustee appointed to handle the estate. So that's a good question. My understanding of Amazon's response was that unless and until Chad was convicted, they couldn't justify taking his books down. He's not making money off of them. He sold the distribution stock to a separate company. When Spring Creek Books went out of business, any print stock that they had, he sold it to a distribution company that then does the distribution. And as far as I know, I don't think there are many people out there buying his books. I bought a couple of them. I tried to buy them used so that he wasn't generating any new sales. But I did buy a couple of them. I downloaded a couple of them free on Amazon on Kindle. So, hi, Squeaky Wheel. Question: can Chad and Lori talk by phone or written letters now that she's convicted and he isn't? Should be great for the prosecutor or not? Well, the prosecutors actually filed a motion asking the court to clarify the order about whether or not they could have contact. There was a no contact order at one point between them, but the court clarified, Judge Boyce clarified, that there was no longer any prohibition between them talking on the phone or corresponding by mail. I think that that may be helpful to the prosecution. I don't know. Lori and Chad have been pretty cautious about what they have talked about. Now, I know that there is at least that one phone call that she made to him while he was outside and they were serving the warrants in his yard. But even that one was couched in some fairly vague terms. If knowing what happened, knowing what was found in the backyard, I think you can sort of jump to the conclusion that Lori was asking, are they seizing stuff again? I think she was, trying to ask him, have they found the children? However, she didn't actually say that. So as far as I know, the prosecution has not asked for them not to be able to talk to one another. Everything they say or write is going to be recorded and turned over to the prosecutors. So I don't know what sort of conversations they'll be having. I was told that before Lori's trial, while Chad was in jail in Fremont County, that he had pictures up in his cell of his children and of Tammy, but there were no pictures of Lori. So, it's anecdotal. I can't prove it. I can't verify it, but that's what I was told. So, Alabama. Lori, did you see the polygraph show with Casey Anthony's parents? Do you think they're being honest? I did not see the polygraph show with Casey Anthony's parents. I don't believe that Casey Anthony's parents have ever been honest. I don't believe that they have ever been fully forthcoming. Now, I read both books. I read the prosecutor's books and I read the defense book. I read Jose Baez's book and I saw the documentary recently. I think it was Netflix. I don't recall. And I understand why the jury found there was reasonable doubt and found her not guilty. And I do think that her description of Kaylee going in the swimming pool, someone leaving the ladder up on the above ground swimming pool, and Kaylee going in the pool and drowning was a reasonable explanation, and that the grandfather panicked and got rid of her body. She alleges that her father was abusive to her and that she was, because of his past abuse, she was not brave enough, didn't have enough courage, didn't have the strength to go to authorities and actually tell them what happened. I don't know whether that's true or not. I don't know that we'll ever know the truth. What I can say is, as a lawyer and having read both books and having seen the documentary, I can see how the defense raised reasonable doubt. And I can see why a jury could not find beyond a reasonable doubt that she was responsible, directly responsible for Kaylee's death. So that's kind of where I come down, but I have never believed that either of her parents were honest from the beginning. I think that I definitely think that her mother had ulterior motives, and there were odd dynamics in that family that are kind of inexplicable. So we're at the 2-hour mark, folks. So let me answer this question. Don't worry about me. And then we'll say goodnight. What do you think the prosecution's biggest trial will be convicting Chad guilty? If you're asking what I think their biggest challenge will be, I think their biggest challenge is the same challenge they faced with Lori. And that is, they don't know who actually committed the murders, and they don't know where they were committed. Now, they have an admission from Lori that the murders occurred in Alex's apartment. And I guess you could infer from that Alex was the responsible party. But I think that they need to be cautious about that in the way that they present it to the jury, because the jury only has to find that they all conspired and one person took a substantial step to carry out the conspiracy for him to be guilty of conspiracy to commit murder. So I think what will be interesting is to see what evidence they have that convicts Chad of Tammy's murder, because he is charged with her murder and Lori was not. So that they're going to have to make that connection. And is it going to be enough to prove that he was in the house he and Garth were the only two people in the house? Maybe. But we also have Alex 2 miles down the road in a church parking lot as Tammy was being murdered. So that will be their challenge. But I think that if they present the case the same way that they presented Lori's, they're on pretty good ground. So how would Kay and Larry receive the remains if Colby is next of kin? Linda, good question again. If Colby gives them permission, it's his decision to make. If he turns the remains over to them and gives them permission to make the final arrangements so the kids can be together, he has the right to do that. It'll solely be his decision. So, and I want to point out that is a lot to put on a young guy's shoulders. He is still young, and he's been through it, and it's a lot. So I hope he's getting lots of support. I hope he is getting lots of therapy, and I hope he has people surrounding him who are helping him make that decision. So, good question. I want to thank everybody for for tuning in tonight. I hope you all had great holidays. I'm anxious to read through the chat afterwards and hear about your New Year's intentions, setting your intentions for the new year. Y'all know mine, marketing a bestseller. So thank you so much for joining us tonight, 267 of you. And thanks, as usual, for being part of our crew. Thanks for the fact that I think we have the best chat on YouTube and the best group community. And I just want to say thanks again for joining us. And we will see you next week. If we didn't get to your question in the chat, or if you think of a question and would like to post it in the comments below, please do. If you're the kind who doesn't really like to make your questions public, email them to me. My email's in the show notes. And I'll look forward to chatting with you next week. Hopefully, Michelle will be on the mend. And until then, I'm going to say thanks to Jen and good night.